If you have a pending green card application or are about to submit a green card application from within the United States, there has been a major policy shift that you absolutely need to know about.
Adjustment of status just got a lot more dangerous. Immigration just released a shocking new policy memo emphasizing that adjustment of status is not a right.
The Trump administration is rolling out a major immigration policy change that could force green card applicants to leave the United States while waiting for permanent residency approval.
Wait till you hear this shit. The Trump administration just radically changed the green card process, making it so much harder to get a green card. Because now, if you want to apply for a green card in the United States, you have to leave the United States to do it. Before, you can come to the United States, begin the green card application, stay in the United States while it's pending. That's going to change. The Trump administration now says most people who apply for a green card actually have to go back to the country of origin, essentially where they're coming from, and they're going to have to apply for an American visa through the American consulate in their home country. It's going to impact students, tourists, so many people. And get this, there's currently a travel ban in place for 39 countries. So how are they going to come back into the United States of America? I don't know. For others, they're going to have to go back to countries where they may have faced persecution, or countries where there are ongoing civil wars. Policy takes effect. It's likely going to be challenged in court. We'll see what happens. I'll have more updates for you soon. Spread the word. Follow along to stay up to date on all the news you need to know about.
The Trump administration is rolling out a major immigration policy change that could force green card applicants to leave the United States while waiting for permanent residency approval. New guidance from U.S. Citizenship and Immigration Services says people living in the U.S. temporarily may now have to return to their home countries to complete the green card process. The change could impact spouses of U.S. citizens, foreign workers, and migrants already legally living in America. For some applicants, leaving the country could also trigger re-entry bans lasting up to 10 years under existing immigration law. The administration says the policy restores the original intent of the immigration system and discourages visa overstays. And this move comes as Trump continues pushing tougher immigration policies while also promoting his Gold Card visa program, which offers wealthy foreigners a fast track to residency for $1 million.
USCIS has just released a new policy memo that has everyone panicking because the title makes it seem that if you want to apply for a green card, you must now leave the United States and return to your home country to apply. But let me break this down for you and tell you what this actually means. The problem with this policy memo is that it makes it seem like if you have a green card application pending, or if you plan to apply in the near future, that you must immediately leave the United States. However, the policy memo does not override existing immigration laws because there are federal statutes already in place that still allow many people to apply for their green cards while remaining in the United States. What this does tell us is that USCIS is going to start scrutinizing, meaning it's going to be very more tougher and harder on green card applications, much more aggressively than they were before. So we can expect more RFE, more delays, and more discretion, meaning that the officer has more room to deny your application, so there's less room for mistakes. It doesn't mean that you need to panic, that you need to leave the United States immediately, or that you should just give up on applying. That's not what that means. What it means is that there are less room for mistakes and errors. You have to make sure that you're submitting your application correctly the first time. My name is Bumka Canoe, and I'm the principal attorney at the law office of B. Canoe, a full-service immigration and cross-border law firm. If you have specific questions as to whether or not this is going to impact you, send me a message in my DM or click the link to schedule a meeting, and you will meet with me one-on-one so we can discuss this.
Are now no longer saying that adjustment of status is a normal process to get a green card. And they are expecting everybody to process for their green cards at a U.S. embassy abroad, not adjust your status. This is a huge philosophical shift for U.S. immigration because for years, adjustment of status through marriage inside the United States has been very common. Since the time I have been born, 50 plus years ago, I don't want to age myself. Now, USCIS is basically telling immigration officers to heavily scrutinize every adjustment case. The memo specifically tells immigration officers to look negatively at people who overstayed their visas, people with status violations, people with unauthorized employment, people with conduct inconsistent with their original visa purpose. Now, immigration is also emphasizing preconceived intent much more heavily. So that old 90-day rule, wait 90 days and then get married about that we always talk about, that may be down in the garbage now. We honestly do not know yet or even know if USCIS is going to effectively ignore that 90-day rule and do something completely different. Because this memo strongly suggests they may start asking, what was your real intention when you came into the USA? Did you really intend to come temporarily? Or did you intend to stay permanently all along? Even if you married 180 days after you came here to the US. So this means entering on a tourist visa and later marrying a US citizen is going to be much more heavily scrutinized. People with overstays, unauthorized employment, questionable travel history, inconsistent social media, prior violations, inconsistent statements could all potentially face much more strenuous questioning at an adjustment interview. And the memo even says applicants may need outstanding equities to overcome these negative factors. And that is a real dangerous phrase, because what qualifies as outstanding equities? Who the hell knows? So my argument is immigration cannot simply invent new requirements through policy memos. So I expect major litigation over this.
If you have a pending green card application or are about to submit a green card application from within the United States, there has been a major policy shift that you absolutely need to know about. USCIS has just dropped a new policy memo instructing officers that adjustment of status, or the process of applying for a green card from within the United States, should only be granted in extraordinary circumstances. And that is a really significant shift, because for decades, Congress actually expanded access to adjustment of status. So people didn't have to leave the United States, go travel to an embassy or consulate in their home country abroad, and complete the process from there. The law was intentionally designed to help people who are already here. This includes employment-based workers, people applying for green cards based on family relationships, or individuals seeking humanitarian relief. But this new memo flips the framework. USCIS is now saying that simply being eligible is no longer enough. Even if you entered lawfully, even if you've maintained your status, even if you waited years in a backlog, even if you have zero negative factors, you haven't worked without authorization, you haven't broken a law. The memo specifically says no adverse factors is not enough. And this can and will impact hundreds of thousands of cases currently processing and about to be processed. One of the biggest concerns is how this is going to affect humanitarian parolees. Think the Afghans who we abandoned in Afghanistan and are now trying to seek refuge here, or the Ukrainians who have fled a war-torn land. This memo actually suggests that applying for a green card from within the United States can actually be viewed negatively because when you entered, your entrance was supposed to be temporary. Many of those individuals cannot safely return to a consulate. With our travel bans happening right now, we have nationals from at least 39 countries who cannot safely exit and return to the United States. The government's effectively criticizing people for not using consular processing while also making it impossible for them to return. For many employment-based immigrants, like those from China or India who have put down roots in the U.S. and spent years working towards this, they have tons of uncertainty now. Now many are left wondering whether following every rule will be enough. This is not new law passed by Congress. It's a policy change in how USCIS is choosing to apply discretion. I think we are going to see significant litigation and challenges surrounding this in the months to come.